Good morning. Welcome to IOS Online Tuitions for Judicial Services. Today we start with the Transfer of Property Act 1882. Okay. As far as possible, we will be going section wise. If it is not needed, then we will do the entire chapter as a whole. Okay. So we start with Transfer of Property Act 1882. Short title and extent. Where all does it extend? It extends to all the states where the official gazette notification says that it extends to. Okay. And where the Indian Registration Act extends. Wherever the Indian Registration Act, or whichever is the territories to which the Indian Registration Act extends, Transfer of Property Act may extend as per the official gazette notification. Okay, we go to section 2, Repeal of Acts. Repeal of Acts, whatever, that is the savings clause. Okay, whichever other act which has been enacted or amended later, at the later stage, those shall be the acts to which the topics will relate to, and it will not fall into transfer. Then we go to section 3, Interpretation Clause. Interpretation Clause, we have the definitions. Okay, we'll just quickly go through it, which are all the words which are coming under the definitions part. That is the immovable property. Okay. Immovable property, anything which is not movable. So when you are talking about immovable property, anything which is not movable, what are movable properties? Movable properties, how can you define movable properties? You have to go to Sale of Goods Act. What are goods? Anything which is movable, right? But when we say movable, again you have to refer to Sale of Goods Act, which talks about anything which can be severed from earth. But anything which is embedded into the earth, even if it is a machinery which is embedded into the earth, then it will be deemed to be immovable. Okay. Then next, instrument. Instrument is anything which is not a testamentary instrument. Anything which is written down means a non-testamentary instrument. Anything which doesn't act as a documentation. Attested, of course, attested by the due authority. Attached to the, then we go to registered. What does registered mean? Registered means anything which is registered under any law for the time being in force. Then attached to the earth. Attached to the earth means anything which is attached. See, just now I was telling you about the machinery. Machineries usually are movable property, am I right? But if it has been really attached to the earth, it has been embedded into the earth, then it shall be deemed to be a immovable property, attached to the earth. Anything which is attached to the earth. Attached to the earth means it cannot be severed from earth unless you have to remove the part of the earth from the good property. Okay. See, for example, we call houses also as immovable property, something which is attached to the earth. But we can easily demolish the earth. So that doesn't mean it can be severed from earth, therefore it is movable property. Am I right? So when we are saying movable property, immovable property, anything which we can sever from earth, please don't take it in a very wide sense. Then next we go to actionable claim. What is an actionable claim? Any debt, any claim which can be made a cause of action. When do we make it a cause of action? Anything which can be enforced by the law. Then we go to the next one. Okay, I think that is it regarding definitions. Then we go to section 4. Enactments relating to contracts to be taken as part of Contract Act and Registration Act. See, when we are talking about all this transfer of property, obviously Transfer of Property Act means transfer of property relating to immovable property. Therefore, when we have to keep in mind the Indian Registration Act as well as the Contract Act, because you know it. Sale deed, gift deed, whatever is the type of deed, everything acts as a contract. Okay. So now we go to chapter 2 of transfers of property by act of parties. Chapter 2 of transfer of property by act of parties. How does the transfer take place? Transfer takes place because of the acts of the parties. Okay. Transfer means what? Any title, any possession, risk, anything that will be transferred. The good itself is transferred. The item itself is transferred. The property itself will be transferred. Everything will be transferred due to the act of parties. That is what chapter 2 deals with. You have the mortgage deed, you have the mortgages, you have lease, license, which gives only the possession, not the ownership. Otherwise, you have absolute sale deed, you have a gift deed, you have power of attorney, you have so many such things, right? Through which transfer of property takes place. Section 5 defines transfer of property. What does it say? Transfer of property means an act by which a living person conveys property in present or in future to one or more other living persons, or to himself or to one or more other living persons, and to transfer property is to perform such act. So what is the main criteria over here is living person. Main criteria for this section is the transfer by the act of the party should be to a living person. It may be himself or it may be to any other person. Doesn't matter. But what happens? The person should be a living person. Okay. See, definitions and all you have to only by heart. But I would like to analyze and tell you exactly what is important in that, so that it will be easy for you to by heart the definitions. Okay. Okay. And this is the main thing which is there in the section 5. Living person. We cannot transfer any property to a dead person. But you should remember one thing. Any person, living person, does not necessarily mean who is existing in this world. Right? You have already read in LLB. Existing in the world, living person also includes a child in womb. Such a baby, such a child in womb is also deemed to be a living person. So, to be existing in the world, what we have to think of is also the child in womb. We have to include. That's why if you go to see certain partition deeds or gift deed or something like that, you have a clause. If it has been given to the child in womb, then that clause will be written down. Obviously, the guardianship will be to the mother or father, being natural guardians. Okay, then we go on to section 6. What may be transferred? Very important. Of course, we know that it is properties which will be transferred. But what may be transferred gives you a wide idea. Number 1. Heir apparent. Chance. The chance of an heir apparent succeeding to an estate. Chance of a relationship obtaining a legacy or any other possibility of a like nature cannot be transferred. We cannot transfer the future right. If you are having the textbook in your hand, you can just note down there. Chance of a heir apparent succeeding to an estate. Chance of a relation obtaining a legacy on the death of a kinsman, or any other mere possibility of a like nature cannot be transferred. Okay. So what all can be transferred? Everything can be transferred. All sorts of properties can be transferred. But what cannot be? All rights can be transferred. All liabilities can be transferred. Anything may be transferred. But what cannot be transferred is future right. If a person has written a will in my name, then I cannot say that, okay, I am going to sell you the property because the will has been written in my name regarding that property. Till the testator dies, I have no right. I am just waiting to succeed to that property. Understand? So, a future right cannot be transferred. Number 2. An easement cannot be transferred. We know this, right? Easementary right. See, if suppose I am a tenant in a house and I have the right of passage to certain to a particular gate and then go to and fro, right? So I cannot transfer that. Just because I have an easementary right, even if I'm the owner of it, I cannot transfer the easementary right to some other person. If you would have noticed, some of the people, what they do is they give their parking lot on rent to somebody else. Actually, that is not correct, right? But they do it. So easementary right is a right which is attached to the property. It is not a separate right. Even though it is hence easementary right cannot be transferred. Understand? Right to passage, air, light, am I right? So all these cannot be transferred to anybody else. Number 3, all interest in property restricted in its enjoyment to the owner personally cannot be transferred. Any restricted rights of enjoyment which is personal in nature, mind you. Restricted rights of enjoyment which is personal in nature cannot be transferred. What do you mean by restricted right? Even though the person is the owner. Just now I gave you the example of easementary right of an owner. Owner has all the rights to enjoy easementary rights, am I right? But just because he has all the rights to enjoy the easementary rights, he cannot transfer it. Why? Because it is personal in nature. Number 1. It is restricted. Number 2. Why is it so? Because it is personal in nature, so therefore it is a personal right. It is a restricted right. That means what? You have read in Constitution. What is Constitution? Freedom at arm's length. Right? Just because I have the freedom to do so many things, I cannot go around harassing all the others. So what we call it as freedom at arm's length. Rights at arm's length. Same way, where there is a restricted right, that right cannot be transferred to the any other person. Okay? Then next one. A right to future maintenance. Again, we go back to the first one, what we have read. Future right cannot be transferred, right? So, future maintenance right. Right to future maintenance obviously cannot be transferred. See, why? Because it is not existing. The problem here is anything which is existing can be transferred. But where it is not existing, how can I may get it, may not get it. If you have read the Contract Act, you should read Contract Act along with this. If you read the Contract Act, anything, this is like a contingent contract, am I right? So anything which is in future is not existing now. So we may get, we may not get, hence it cannot be transferred at present. In future when I get the maintenance, I can transfer it, but not now. Okay? Then number 5, mere right to sue. Right to sue cannot be transferred. I have a right to sue a person. Can I just transfer it just like that? No. See, just like that we cannot transfer it to any other person. There are riders to it. For example, if it is an insane person or a minor or an insolvent, particular cases are there. But generally a right to sue cannot be transferred. I cannot just write down a sale deed or something like that and say, come on, I am transferring the right to sue to you. I cannot. Right? Okay. Then next one, number 6. I can only act as an agent. That's all. I cannot get the right to sue as an owner. Public office cannot be transferred. We know this very well. Public office cannot be transferred. What do you mean by public office? Any authority who is holding a public position. Right? A public position, they have to come either through elections or through promotions or something like that. Only the particular ways are there, particular means are there of coming to public office. So it cannot be transferred as a matter of right. Oh, I have been there in public office. Now let my son or daughter take my place. That is not the way the public office works. Okay. Then next one is stipends. Stipends to military, naval, air force and civil pensioners of the government. And political pensions. Stipend for defense personnel, civil pensioners and political pensions cannot be transferred. Stipends means what? Whatever comes as a part of the money, it cannot be transferred just like that. We have specific situations in which it is transferred, but stipends can never be transferred. Okay, then next one. Then, no rights. See, where there is an unlawful object. What is the unlawful object? What do you mean by unlawful object? Any purpose of a contract which is unlawful. And there arises a right out of the unlawful object. This right cannot be transferred. The contract which is entered into, the purpose of the contract is unlawful. But even though it is unlawful, I get a right out of the contract. But that right cannot be transferred. Why? Because it is unlawful object. Therefore, it becomes a void contract. That's it. Okay. Then next one. Okay, that is it. Then we move on to the next section. Section 7. Persons competent to transfer. Who is competent to transfer? Any person who has a right, title or interest or ownership, and anyone who acts as an agent of the person. So anyone who has been authorized, either the person himself or anyone who has been authorized to act on behalf of the person who is entitled to the right, shall be persons competent to transfer. See, for example, if I am not in town, okay, but a sale deed has to be registered on a particular date when I am not there. So what do? I cannot miss the appointment which I have in some other place. So what do? I give a power of attorney to one of my persons, whoever is there. Okay. So that means they have the right to act on my behalf. So who is competent to transfer? Apart from competency of parties which we read in Contract Act, what you have to remember is either the party himself or his authorized agent has the right to competent to transfer. Then we go to section 8. Operation of transfer. Operation of transfer means what? When does the transfer take place? When does it take place? What is it? Unless a different intention is expressed or implied, transfer passes forthwith to the transferee all the interests. So how does it get transferred? All the interests are transferred. We have read it in sale of goods, right? In sale of goods, what do we read? Goods gets transferred, ownership gets transferred, risk gets transferred, possession gets transferred. Am I right? These are the 4 things which we did in sale of goods. Same way, here what do we see? All the interest in the goods and the property gets transferred to the transferee. Okay? So, and then right, interest, ownership, possession. Ownership may pass on or may not, but right, interest and possession surely pass on to the transfer. Okay? Where it is an actionable claim or a debt or anything, then the debt is not directly transferred. Understand? The debt is not directly transferred, but what gets transferred is the claim over it. For example, the interest which is gathered. See, if I have given a debt to somebody else, Okay, and I am filing a suit for that. But I have taken a loan from somebody else. So how will I transfer the debt? How will I transfer my actionable claim? See, for example, in case of insolvency petitions, insolvent cannot file a case for anything except what is due to him. If he has to get something which is due to him, then he has the right to file a case, right? Of course, through his agent, but still. Okay. So in that case, what happens? He will file a case saying that I should be getting so much amount from so and so person, hence I am filing a suit for this claim. Understand? Now, if somebody else has to attach my actionable claim, the insolvent person's claim, then he can attach, or he will have only the interest, arrears of interest. Understand? So what I can transfer, or what can the insolvent person transfer? Insolvent person, or any person for that matter, can transfer only the arrears. They cannot transfer the debt as it is. Am I right? They can only transfer the arrears which will be due. Okay? Then Section 9, Oral Transfer. What is an oral transfer? Anything which is not in writing is a oral transfer. Okay? Not in writing, as per Evidence Act, how will you see? If it is not writing, means manual, electronic record, both you should take into consideration. Then we go to Section 10, Condition Restraining Alienation. Where property is transferred subject to condition or limitation, absolutely restraining the transferee claiming from parting or disposing of, the condition or limitation is void, except in the case of lease where the condition is for the benefit of the lessor or those claiming under him. See, for example, okay, let me just finish the whole section. Where the condition is for the benefit of the lessor or the one claiming under him, provided the property may be transferred to or the benefit of a woman, not being a Hindu, Mohammedan or Buddhist, so that she shall not have power during her marriage to transfer or charge the same or have any beneficial interest therein. Okay, so now what we have to see over here is condition restraining alienation. The condition restraining alienation. See, when we are alienating a property, it can be either through sale or gift or will or release deed, anything, okay, D capital, anything it may be. There should not be any condition, restraining condition. Condition restraining transfer. Understand? There should not be any condition restraining. See, if I am getting a property from, say for example, A is giving a property to B, and A says, you shall not do this, you shall not do this, you shall not do this. These conditions will be deemed to be void unless it is for the purpose of lease. See, when we are giving a rental agreement, we say you should not put nails on the wall. You should not do any painting. You should not scratch the wall. There are so many don't. Right? So in a lease agreement, the conditions restraining is valid. But otherwise, it is not at all valid. You should not sublet the premises to anybody else without the owner's express permission. That also comes under Section 10. Okay? Thank you.